morning, Your Honors. May it please the Court.
Good
My
morning.
name is Michael Clark, and I am here today on behalf of the appellants, defendants below, Whiteman and Universal Computer Systems. I'd like to reserve 5 minutes for rebuttal.
All right.
Your Honors, the relief that we're requesting is reversal of the order that granted the plaintiff a new trial in this case, and that the jury's verdict be reinstated with the direction that the judgment in the defendant's favor be entered. Alternatively, if the court does feel that a new trial is warranted, we ask that the new trial be limited to the issue of causation solely relating to Mr. Sanson's need for emergency medical care. Those are the two primary points that the trial court found there to be a clear and convincing problem with the manifest weight of the evidence that was presented to the jury. And the conclusions that the trial court made really set a bare minimum standard in its subjective view of what that evidence was. On the issue of negligence and ultimately on liability, there were at least three factual findings of the trial court concerning the circumstances of this motor vehicle accident that caused it to have the concern that it did in terms of the jury's conclusion. The first was that there had been an immediate lane change preceding this accident. The second was that this was a side swipe type collision. And the third was that the defendant made his lane change without seeing a vehicle, and that all of the evidence on those 3 points, those three factual points, was undisputed in the record that had been submitted to the jury. And the second basis concerning the emergency room treatment, he concluded that there was an abundance of evidence supporting the claim that the plaintiff's injuries for which he received treatments was pre-existing, but at the very least, the trip to the emergency room on the day of the accident was as a direct result of the motor vehicle accident. The standard of review in this case is varies somewhat between the 2 points. On the second point concerning the emergency room treatment, the argument that we have made and presented is that there's an error of law there, and that de novo review should be applied to that error of law. That is, the trial court applied the general rule, which is to rule in or rule out a causation issue. An emergency room treatment is that bare minimum that has to be awarded when the evidence supports the award of it. The first issue is more of a pure abuse of discretion standard, where there is no error of law. And I'm going to rely and hang my hat on, for the first issue, this court's opinion in Kmart versus Collins, which is a manifest weight of the evidence case, dealing with a premises liability action and a fall, where the jury concluded that the plaintiff was 70% negligent and the defendant was 30% negligent. And Judge Alterburn's concurrence in that opinion stated the test in this fashion. If all reasonable persons correctly applying the law would conclude that the ruling is improper, then there's been an abuse of discretion. The panel's decision and opinion states the test very similarly, and it says, if reasonable persons could not differ, that the trial judges, was improper due to its insufficient reasoning, that there would be a reversal. Now, in the Kmart case, what the trial court found under that standard, or what the trial court said in its order, was that the evidence was conflicting about the amount of water that was on the floor. The plaintiff described it as a large puddle. The employees of the Kmart described it as some droplets. And what the court concluded there was, in granting the new trial, that the testimony taken from the representatives of the defendant was to the effect that the amount of such water was minimal, and that the site of the accident was a small, relatively narrow hallway which was not presented as a place of great illumination. And the trial court concluded that it could not find any criteria, evidence, or argument advanced by the defense upon which the jury could have based the finding that the plaintiff was 70% negligent, a 70% comparative negligence when the impediment was water, was not readily honest, was readily obvious, and was beyond the realm of appropriate interpretation. It is contrary to the manifest weight. This court reversed that and found under the standards that we've talked about that that was essentially a mere disagreement with the evidence that was presented. So what were the facts that were presented to this jury concerning the driving actions of these individuals at the time of the accident? The record reflects that the best witness was Mr. Whiteman, the defendant. And remember, we're looking here at
how does he become the best witness? When I think I recall Mr. Sanson's wife testified about the abrupt lane change.
You know,
why is he better?
Well, for two reasons. And I'm not disagreeing with the court's review of the record in terms of it's being an abrupt lane change, but there was no indication in my reading of the record that this was anything but a signal turn and a deliberate motion from the right-hand lane to the left-hand lane. He becomes a better witness because Mrs. Sanson's recall was very, very limited in terms of the facts of the accident. She said at the time that her sole testimony was that she saw the directional of the Whiteman vehicle, the signal for the lane change, and then she used the word guess in the record. I'm guessing that he was, you know, we were halfway parallel at that time that happened. But that same witness was impeached on a pretty critical point that both parties have discussed on this aspect of speed of the vehicles. I want to make it clear, we have not argued in our initial brief or in our reply brief that the Sanson vehicle was speeding, that it was driving in excess of the speed limit. But you can take unreasonable driving actions, even if you're at the right speed limit or within the speed limit, if you don't control your vehicle. And that's part of the statute that was read to them. So what Ms. Sanson said, and why Mr. Whiteman is a better witness, is because she was forced to admit in front of the jury, who should be the fact finder here, that she was not out on her Sunday errands or on a Sunday drive. In fact, at 1:30 when this accident occurred, she was driving to the tow yard to pick up a battery so that she could drive back to Temple Terrace, put it in her car, and go to her workplace by 2 o'clock. So, you know, there's a purpose here. So the jury heard that this witness, who gave solely the testimony on seeing the directional signal and then the relative position of the vehicles at the time the turn or the lane change was instituted, was not credible. The jury also heard that there was a reason why the gap closed between the time when Mr. Whiteman began his deliberate lane change to the point of impact. And the point of impact, this was not a sideswipe collision, which again, there's no indication from the testimony concerning the vehicle damage that this was, as the trial court described it, a sideswipe collision. The testimony is that the front portion of the tow truck, remember this is a tow truck that these folks are in, which gets us to the point of, you know, appreciating its presence in the roadway, that the front passenger side of the tow truck struck the rear driver's side at the wheel well of the Whiteman's vehicle. So it wasn't, there's no view of the evidence that supports the idea that this was a sideswipe collision, or at least how that term is commonly defined. There's no record support objectively of the fact that this was an immediate lane change. And there's no objective support that the idea that the evidence on these facts are undisputed. They were disputed. So what Mr. Whiteman said was that he turned his indicator on after he passed the intersection at 21st Street. He checked his side view mirror. He started the lane change and was halfway into the change when he felt it, the collision occurred. I've described the point of impact, and after that point of impact, the tow truck was traveling with sufficient speed that it left the roadway and struck a building on the side of the road, crashing through the wall. Now, these are folks who testified, the plaintiff testified, that they were traveling 30 miles an hour. Don't need an accident reconstructionist, don't need to be an expert to know that a tow truck does not take that type of action after an impact at 30 miles an hour, that it leaves the roadway and goes into the side of a building and through and into the side of the building. That's within the common sense of any juror to know that that vehicle was traveling at a speed that was unsafe for the circumstances of the roadway.
Yeah, but there's a difference between the mass of a tow truck and the mass of a Ford Escort. It's not evident to me that it's self-evident that it was speeding.
Right. Well, if Your Honor is of the opinion that an expert is required to testify about the relative weight of the vehicle and its post-impact actions, I understand the point. But the jury is free to use its common sense. It was instructed to use its common sense. It was instructed to use and draw inferences from the evidence that was presented. And the evidence presented was that these folks didn't admit that this wasn't a simple Sunday drive, that there was a purpose to this trip. So I think they are free to conclude on their own that the speed of the vehicle, again, I'm not suggesting that we have or presented any evidence that it was speeding, but that the speed of the vehicle, again, and it's not only the only statute that was read to the jury was, the statute was read, two statutes were read to the jury, and one of them included any person operating a vehicle upon the streets of the highway within the state shall drive in a careful and prudent manner, having regard for the width, grade, curves, corners, traffic, and all other attendant circumstances so as not to endanger the life, limb, or property of any person. That's right after the negligence instruction in the order of these instructions.
But we're getting far afield here, I think, from what our focus needs to be. And our focus needs to be is when the trial court granted the motion for new trial, the trial court, of course, has a duty to weigh the evidence at that time, consider the credibility of the witnesses, and determine whether the jury's reached an unjust decision. That's what the trial court's doing at that time. And as we sit here, we're supposed to examine what the trial court did, and if reasonable persons could differ as to the propriety of the action taken by the trial court, then the action's not unreasonable according to the standards that we have to work by. So it would appear in this case that this was, the jury made some decisions based on evidence that it had before it. The trial court considered that, weighed the credibility of the witnesses, and determined that an unjust decision had been reached, so it ordered a new trial. So we now have to look at this and say, well, if reasonable persons could differ on the action taken by the trial court, then it's really not up to us to get involved in it. It has to be so clearly obvious that what the trial court did was right because the evidence didn't support the verdict. I don't think we have that here.
Well, I think what the trial court did was disagree with what the jury determined was the issue in the case.
Exactly. Well, the trial court basically said, I heard this case, I've weighed the credibility of the witnesses, what the jury the verdict they came to was not a reasonable result. So it's not for us to go back and reweigh this evidence, it's for us to go back and determine, apply the reasonableness test to this. If reasonable persons could differ as to what the trial court did then the action is not unreasonable and it's not up to us to go in and disturb it.
It's a high standard. But look at what the trial court said. The trial court said an immediate lane change, and I submit that the record does not reflect that there was a side swipe collision. Again, record does not reflect that. And that it was undisputed that Mr. Whiteman took these actions that were the cause of this accident. And I submit that it wasn't, the record does not reflect that. So the trial court's view of the evidence does fit within that standard, the very high standard, when you look at it from that perspective and the conclusions that it made. So really what we're saying is, could this jury have concluded that Mr. Sanson violated 316.1925? Yes, they could have concluded that, and they did. Could they conclude that his speed was not reasonable under the circumstances and find that he was the sole cause of this accident? They could. Could they conclude that his speed was excessive for the driving conditions? They could. And could they conclude that Mr. Whiteman did not take any inappropriate driving action, and that this was simply an accident? And I do want to make this point because
you're getting into your rebuttal time, and
okay.
You know, you've got about 4 minutes left now. Use them as you will, but I just want to let you know.
I'm going to make this point and sit down.
Sure.
I want to make it clear that in our initial brief, we were not arguing that the directed verdict standard is the same standard that should be applied to this court's review of whether or not a new trial should be granted. What we were arguing was that the comments, and it's been labeled a tempting argument by some of the appellate courts, and I think it gives us some insight as to why those 3 points in the order should be looked at seriously within the high standard that is necessary for us to have the reversal. And what the court said in denying the directed verdicts shows that he was thinking the same way that I am arguing now, which is, this is one of those cases where the jury has to decide who should bear the brunt of this. Who was at fault, if either side. Now this is after everyone's testified on the issue of the cause of the accident. Maybe they will conclude that accidents happen. And as we know, the law of the state of Florida says that accidents can happen without there being negligence. And to give the plaintiff another bite at the apple under these facts is just a simple substitution of the court's opinion of the evidence presented. Thank you, Your Honors.
All right, Mr. Clark, you got about 2.5 minutes left for rebuttal, sir.
Your Honors, good morning.
Good morning.
Robert Samartin for the plaintiff, Nathan Sanson. Your Honor, I won't get into the standard review. I think Judge Morris, you correctly stated what the standard is here and the reasonableness test and the heightened standard that an appellant has in arguing, or a heightened standard of review that the trial judge enjoys, rather. Your Honor, getting to those facts, or the order rather, the order is proper, would ask the court to confirm Judge Barton's order granting plaintiff's motion for new trial. The rules require that the judge set forth in his order specific facts as to why he took his reasonable action in granting a new trial. He stated specifically that the evidence was undisputed. Well, there's 2 issues here, Your Honors, the facts of the accident and the reasonableness of awarding medical treatment. As to the undisputed nature of the evidence, we did reference the testimony of all of the fact witnesses in our briefs, and I know counsel alluded to that in his briefs. Judge LaRose, you're correct. Ms. Sanson did give undisputed evidence that as the 2 vehicles traversed down Columbus Avenue, they were nearly side by side and parallel, that they were her vehicle was traveling within the posted speed limit, and then she saw the blinker of the Whiteman vehicle go on in the front, and that he then made this quick lane change. He was essentially trying to make a left turn from the right lane after Mr. Whiteman had missed his turn previously, only a few blocks from here. And, there was Columbus is one way with 2 lanes. So he had missed his turn. He was making a quick left from the far right lane, and that's when he hit the Sanson vehicle. Counsel references, I think this is where the jury was confused. They will tell you that there's no evidence in the record regarding the speed of the Sanson vehicle or excessive speed. But then they, of course, argued that to the jury or inferred that there was excessive speed. There was no accident reconstruction expert that talked about forces. There wasn't any testimony as to the length of space between where the impact occurred and the tow truck was forced through a bodega, which was literally right there on the corner of Columbus and 22nd Street. Just a synopsis of just how lacking in evidence to support their position. Mr. Whiteman's testimony, we referred to this in our brief. I'll just read it briefly. This is the most succinct example at page 2628 of the record. I was questioning Mr. Whiteman. You can't see out that mirror. He answered, no, not unless you move your head. So you didn't see as you started your turn, you saw a vehicle 5 vehicles back. I don't know if it was that far, but about 4 or 5. That was just an estimate how far back it was. In my judgment, it gave me room to move over. Question, you don't know if Mr. Sanson was right there in your blind spot or not. Answer, no, I don't know if he was there or not. Question, so you heard your attorney argue that this accident was Mr. Sanson's fault. That was a reference to her argument in opening. Answer from Mr. Whiteman, I've heard that, yes. Question, you don't know that, do you? Answer, I don't know that for a fact. Question, you don't have any information that that's the case? No, I do not. Question, your wife is Donna? Answer, yes. She doesn't know either? No. So he was asked specifically, what is the action of Mr. Sanson that could have possibly contributed to this? And he testified clearly in contravention of his lawyer's argument to the jury that the accident was Mr. Sanson's fault. The only other witnesses other than Ms. Sanson said, we don't know what Mr. Sanson could have done that could have constituted negligence. So when Judge Barton writes in his order that the evidence of the accident is undisputed, that it was Mr. Whiteman's fault, that's well established, and reasonable persons really can't differ from that. As to the issue of reasonableness of treatment, the courts are well aware of the line of cases. This court just ruled in Meadowbrook Meat Company back in February, and that case referenced the Rosario case, the Koletsky case, the Martin case. Those are cases from the 2nd District Court of Appeal. It talks about the fact that once liability is established, that despite what the jury finds about permanency of injury or long-lasting nature of injury, that it is, once liability is established, that a diagnostic testing or award for diagnostic testing is reasonable and should be awarded to see if the claimant did suffer injury from the subject accident. In this case, the judge wrote in his order, which kind of tracks the language of those cases, that once the liability should have been established, that it was reasonable that Mr. Sanson, at the very least, and that's what he wrote in his opinion, responded to the emergency room that very day within hours, received diagnostic treatment, and the jury erred on that. Now, there's a problem in this case because of, I think, the dual nature of the question. It's a blended question, which the jury's asked to answer as number 1. Whether or not there was negligence on the part of Carl Whiteman, which was a cause of injury or damage to Mr. Sanson. Obviously, there's 2 issues wrapped up in that single question. So as to the propriety of granting a new trial as to all issues, we really don't know from the jury's verdict what portion of this case they got hung up on, because the jury just simply answered no. So we don't know if they were stuck on the issue of liability, or if they got past the issue of liability and then just said no to all damages, including a reasonable award of at the very least diagnostic testing. Also, Your Honors, I'll just point out that as to the propriety of, or the evidence of injury in this case, above and beyond just the diagnostic testing, the evidence or the record was well documented that Mr. Sanson had suffered not just injuries that would warrant a trip to the emergency room, but that Mr. Sanson suffered serious and permanent injury. It's worth noting that in this case, I called Mr. Whiteman in our case in chief as to liability. And I asked him those specific questions about his knowledge of how the accident occurred and the actions of Mr. Sanson in our case in chief. He was I think the second witness we called. As to the damages, I also called Dr. Vega, who was the defense expert that was hired to review all the records in this case and to examine Mr. Sanson. And I called Dr. Vega once the defendants had decided they were not going to call their own expert. And that was in our case in chief. And I think in writing the opinion, or in the order, Judge Barton used the language of the cases where he said at the very least diagnostic treatment would be in order and should have been awarded or considered. But Dr. Vega very clearly in our case in chief testified that Mr. Sanson had suffered permanent injury, that he could no longer work in his field as a tow truck driver because of the injury that he suffered in his back. Now, there was also evidence that's in the record that once Dr. Vega rendered that opinion, counsel for the defendant sent the doctor a letter with a record asking him to reconsider and to consider another piece of evidence. And so when Judge Barton writes in his order that there may have been substantial evidence that the injury didn't occur in this case, we do disagree with that portion of the order. This is the substance of the pre-existing nature of Mr. Sanson's back injury. It's found at the record at page 2734 through 36, and it's referenced in the appellant's brief. Once Dr. Vega had found that Mr. Sanson had suffered a permanent injury and could no longer work in his field as a tow truck driver and would require medical treatment for the rest of his life, he was asked to consider emergency room record from 11 years prior. And this is the UCH emergency room record that the defense asked him to consider in his opinion and asked him if he would revise his opinion, and he did. He said, well, because of this record, I now find that this injury didn't happen in the accident. And I called Dr. Vega to establish, one, that all of the doctors, including Mr. Sanson's treating doctors and Dr. Vega, considered the condition in his back to be serious and permanent and requiring future medical care. Dr. Vega relied on this record that where Mr. Sanson had reported to University Community Hospital. He showed up, and this was all in the record. He told the doctors at the emergency room that he had moderate pain. They diagnosed him with low back strain, and they prescribed an anti-inflammatory. And at that time, he had described his pain 11 years prior in his back as a 2 out of 10 pain. I then asked Dr. Vega throughout the record, did you review any records that showed any treatment for a low back injury from 2001 through when this accident occurred in 2011? And the answer was no, there was none. So in addition to just the diagnostic testing, which is what the court found at the very least this jury should have considered once liability is established, that the record is well documented. Because we don't know where the jury got hung up on which question, that's why I think it was appropriate and proper for Judge Barton to order a new trial on all issues. And if there's any questions?
All right. Thank you, sir.
Thank you, Your Honor.
Your Honor,
Mr. Clark, you've got 2.5 minutes remaining for rebuttal, sir.
Thank you. Your Honor, on the Meadowbrook case, I think that's a statement of the general rule that if there is testimony supporting that the need for the emergency medical treatment was related to the accident or to rule it in or rule it out, that it can be awarded or should be awarded. But all the cases that apply that general rule have a preliminary finding that the defendant is actually liable or negligent and is the causative actor. We don't have that here. So we've talked about how the first question on the verdict form is phrased. And what was argued in closing argument in relationship to both the issue of negligence and in the relationship to the issue of the damages was the defendant's attorney said, we don't think you have to get past the first part of this question. He says it distinctly. He says, but if you do get there, if you do find that Mr. Whiteman was negligent, go ahead and award the monies for the emergency room treatment. And it's in the closing argument, it's $700 some odd. And what this jury did was award nothing. And what that means is they determined that there was no negligence. So we ask that the court take the jury's findings and reinstate it, reversal of the new trial order. Thank you.
All right. Thank you both. All right, the next case is C.D. versus State of Florida.